feeling omnipresence of the raging pandemic, and we are ever so thankful for him for helping us host this webinar. I have been bestowed upon the duty to give a brief introduction to the topic, but I think we have eminent panelists, and we also have amongst us a judge, honorable judge of the High Court, who is well versed in this area, and I think I will fail in my duty amongst such eminent panelists, and therefore I'm keeping my introduction very short and brief. When you talk about private international law and international law in general, there are already several conflicting areas with respect to jurisprudence and choice of law. And this becomes even more trickier in such a situation. And you could probably very broadly divide it into two categories. You have practical issues, and you also have certain doctrinal issues. Practical issues, I would say, probably summoning, making sure that the defendant is present, summoning the defendant, etc., is a problem amidst the COVID-19 scenario. And if you look at the doctrinal issues, specifically, something that comes off my mind is the doctrine of overriding mandatory provisions, wherein if a party chooses a particular law, the court should actually abide by party autonomy doctrine and go by the law chosen by the parties, but sometimes it can override these mandatory provisions in public interest. The question is whether a health crisis will qualify as a public interest. So these are just areas of relevance today in the light of the pandemic, and we'll probably discuss it in detail with our eminent luminaries on the panel. Having mentor update for the event, our beloved Professor Dr. Sunny, to address the gathering. Sir, over to you.
Sunny, 1 minute.
Hello?
Sunny, am I audible for you?
Yes, audible.
Sorry, I have a program in Judicial Academy, so may I take over you because time is running out for me, so I'll take 5 minutes, okay?
It is all right. I express our sincere thanks. Okay, sir. Please, sir.
Sorry, brothers, for disturbing your program within schedule. Good morning to everyone. Good morning. It's a very pleasure for me to address Anil Malhotra as honorary professor of your university. Perhaps it's the first time somebody is addressing him also. Well, in fact, it's a fantastic opportunity you have capitalized for addressing such an issue of great imminent importance. Well, we are living in times of opportunity. Opportunities galore, especially in legal profession. This is why the legal profession is so demanding. Another profession, legal profession is changing its color and texture. But question is whether are we able to tap those opportunities? Simple issue to be placed before you in the context of deliberation. We are now talking upon private international law. I must appreciate the university and led by Dr. Sunny. The recent past, I've seen many activities are coming from his side to give a exposure to the different worlds. I've seen a couple of international faculty came to your college, came to your university addressing on international law. This is a good initiative. I understand there are constraints for the university developing our own curriculum because they have been dictated by Bar Council of India. But still, taking an initiative, giving an opportunity for you to acquire an expertise and exposure and experience in other fields is great. I must appreciate Vice-Chancellor and other teams of faculty in initiating such steps. With these words, I must just have some thoughts on the private international law. As I said, it's a great opportunity for you to have a kind of exposure to the private international law. There are two approaches to the private international law. One is issues like very stereotype issue, issue-based issues, which we try to put things in within the framework of private international law. The private international law coming to the field when there is a foreign element. Of course, we call it an international law, rather it's a domestic approach to the international, an issue of a foreign element. But we have never used the other aspect of private international law, which is in the transformative character. That's what I'm going to speak to you. For the youngsters, it is for you to take up this task. Issue-based, yes, there are many issue-based approach in the private international law, whether by the international conventions or conventions or by the domestic law. We don't have in India as a codified international law, private international law. It is scattered in different statutes like CPC, Succession Act, etc. But hardly any initiative come from our domestic level for a transformative character of international. That's where the research we require. Because given the advantage of the technology, there is immense importance for a transformative character of private international law. It's not based on any issues, but changing the patterns of a life. Like you just think about how the Uber changed the world by a simple platform of a software connecting all the taxis in the world without owning a simple automotive. So in a way, the private international can't make changes by bringing instruments which are being used in international business or whatever manner. So it is for the youngsters take this opportunity by holding researchers and pushing the stakeholders to accept such acceptance in international level. There are agencies like UNIDRA, Hague conferences, Hague, and many agencies are involved in such research. So you should be part of such research to make the world very closer. Because private international is the only instrument bring all the international in a one platform, except the one is dictated by international bodies rather than for a formation of domestic law like UNCITRAL for the purpose of international arbitration conciliation. But we don't have such kind of dictate in respect of private international law except through the agencies like UNIDRA and A conferences. So law university should start thinking and developing areas for acceptance in the world by large through the research. So you should start about private international law plus technology. Right? That would be a more interesting challenge for the youngsters and university to take up. So with this word, I may conclude because I rushed to the Judicial Academy. There was a program scheduled to start by 10:50 and 10:30. So thank you very much. And I wish all day and have a good deliberation. Thank you, one and all. Jai Hind.
Jai Hind, sir. Thank you, sir, for your words on transformative change to private international law at the domestic level. Our Honorable Justice MUHAMED Mustaque, sir, enrolled in the year 89. He did his master's in space and telecommunication law in French and he was funded by the French government from Paris University. He also did a course in private international law. He has been a key aspects in many of the very prominent Kerala High Court decisions, including the Triple Talaq case. So we are very honored to have you, sir, and thank you for the noble idea. Now I would like to Professor Dr. Sunny to say a few words.
Honorable Justice Mohammed Mustaque sir, Mr. Anil Malhotra, Senior Partner Malhotra and Malhotra Associates, and dear friends. You have heard a person, Honorable Justice Mohammed Mustaque, a jurist and a judge, has a profound knowledge and practical experience in international law, especially public-private international law. You are going to hear Mr. Anil Malhotra. He is also an expert in private international law. He is a person having vast experience as a practitioner, as an academician, and as a motivator. He contributed several books in private international law. Recently, he accepted our invitation to be the honorary professor of National University of Advanced Legal Studies. So, the students can take the benefit of his scholarship and practical experience. With these words, I am concluding because I am not an expert in private international law. Since experts are present, I invite Professor Anil Malhotra for his presentation. Sir, I express our sincere thanks for accepting our invitation for being the Honorary Professor of National University of Advanced Legal Studies. Thank you, sir.
Today we have with us Mr. Anil Malhotra. He's an author, legal analyst, IAFL fellow, and alumni of SOAS London. He has authored several books, he has 9 publications to his credit in international private law. Without much ado, sir, I'm handing over the mic to you. Sir, please kickstart our webinar. Sir, I request you to unmute your microphone so that it is audible for all of us. Anil, sir?
Hello, can you hear me now? Hello?
Yes,
What did he? Hello? Hello? Can you hear me, please?
Yes, sir. Anil, sir, we can hear you, sir. Hello, sir?
Okay.
Yes, sir. Yes, sir.
Good morning, everybody. I'm
Yes.
sorry, we have an internet failure there, so I'm on my iPhone. So, if there is a glitch, one has to devise ways of technology. So maybe this will also become another part of private international law. So anyway, friends, not to keep you waiting, I will open up the topic to you because according to me, private international law is going to be international family law very soon. Differentiating between public international law and private international law. We have now carved out a niche in the area and realm of private international law. And having traveled down the lane of the streets of private international law by starting my innings at SOAS London and venturing all over the world, I find that the growth of this jurisprudence is phenomenal. So much so that in my most recent book, Global Indians in the Law, which I have compiled during the lockdown, I have discovered that the widespread areas in which this jurisprudence is now available is vast. So friends, I am, with whatever time at hand, I'm going to run through 7 parts of this new developing area of private international law in the realm of contemporary issues arising in private international law. So, the very first, most newsworthy amendment facing issue is nationality, citizenship, and OCI's issues. Now, the principal legislations in nationality, citizenship issues is the Citizenship Act and the Passports Act. The Citizenship Act initially meant in Section 9, read with Article 9 of the Constitution, to confer rights of citizenship, of singular citizenship only to Indians. But with an exponential number of 30 million NRIs, that is non-resident Indians, living in 200 countries, we created a category of overseas citizens of India by amending Section 7 in 2005. because we did not principally agree to the argument of dual citizenship. So OCI became a second-rate status of citizenship with limited rights of being able to stay in India without taking a visa every time and enjoying certain benefits which were notified, but you could not partake in elections, you cannot hold a public office, etc., etc. So this is a concept of conferring certain rights on Indian citizens, of citizens of Indian origin who have acquired foreign nationality. Now, with this came very interesting offshoots which are now seen in the amendment of the Citizenship Act, because now in the Citizenship Amendment Bill 2019, which is very heavily being debated, Section 2 of the 21B of the Citizenship Act is being brought in to define who is an illegal migrant, and persons professing number of religions are sought to be naturalized and be given Indian citizenship. So this is a very surprising and development in the realm of private international law, that after introducing dual citizenship, we will now be defining an illegal migrant, and we will be bringing in within the fold of India certain categories of persons who qualify for Indian citizenship. We also have Section 5 and 6 of the Passports Act, under which the passport authorities, there are 13 grounds, the passport authorities can disallow on 13 grounds the passport to an Indian national. Now, this has become very interesting in the question of children who are to be adopted, because we have the adoption regulations in place pursuant to the Juvenile Justice Act and the adoption regulations, in which all adoptions, inter-country adoptions, intra-country adoptions, inter-relative country adoptions are governed by CARA. So the moot question is that if there is a adoption under the Hindu Adoption and Maintenance Act, which does not require any procedural requirements, and that parents are giving and taking an adoption, do we need to go to CARA? Do we need an NOC from CARA? And can the passport authority deny a passport to an adopted child simply because it has not gone through CARA? I'm an amicus in this matter, which is currently being agitated before the High Court. So this is a totally new dimension of the citizenship issue. Now, under Section 9 of the Citizenship Act, the government can determine by a quasi judicial process, aided by the Rule 40 of 2006, which rules 1955, whether a person is an Indian national or not. But then we also see that there is the Entry into India Passports Act 1920, the Foreigners Act of 1946, the Foreigners Order of 1946, under which there is no procedure and a summary deportation can be ordered. Recently, over 3,500 people were sought to be questioned for the Supreme Court, and the issue is, can they be deported without a hearing? Now, this is a completely new dimension of private international law in the realm of citizenship and nationality. Now, since I cannot devote too much time further to this, we will now move on to a very, very hotly old debated issue, that is marriage and divorce. Now, in the issue of marriage and divorce, the development of private international law has been the maximum. The question goes, what is the status of a Hindu marriage in a foreign jurisdiction? Does nationality change the applicability of law? Can a Hindu marriage be resolved by a foreign court? What is the status of a marriage dissolved by a foreign court? If so, and if there is a dual marriage, means there is a civil marriage in a foreign jurisdiction and a marriage in India, which marriage can be dissolved by which court? Now, the answers to these questions are very complex. There have been repetitive judgments in the Supreme Court, but issues now keep reflecting. We have Narasimha Rao's case laying down principally that Indian marriages should only be dissolved in Indian courts. So does visa service. But recently, there has been a judgment of the Supreme Court. And in that judgment, the Supreme Court has held that even if it is established that parties are Hindus by religion, there is concurrent jurisdiction between the foreign court and the Indian court. And it is only when the decree is sought to be executed in India, it will be seen whether the decree of the foreign court was properly obtained or not. Now, the bottom line of the discussion which comes from the judgments is that Section 1 and 2 of the Hindu Marriage Act clearly has extraterritorial application, meaning thereby that if parties are Hindu by religion, whatever nationality, whatever domicile, whatever country they may be residing in, their Hindu law applies to them. So the sum and substance is, if there is a Hindu marriage solemnized according to Hindu law, maybe in India, maybe abroad, it can only be dissolved by a competent court of jurisdiction in India according to the Hindu Marriage Act or the Special Marriage Act, as well, whatever the case may be. There may be a civil marriage solemnized in a foreign court. Reflect on the Hindu marriage. So this means, and the only way you can do it is, you can settle the matter abroad, you can draw up a settlement, you can file a petition for divorce by mutual consent. You can, in the jurisdiction of Punjab and Haryana, and even in Kerala, it is quite popular. Parties are allowed to appear through a power of attorney holder. Evidence can be recorded by video conferencing. Parties need not come physically, and Section 13B can be invoked. The settlement arrived at between parties in a foreign jurisdiction can be made a part of the settlement, which is recorded in the Indian court, and the Indian court takes note of it and dissolves the marriage. And so the issues of divorce, matrimonial property, and child custody can be resolved in this manner, and the matters can be sorted out. Now, then comes the issue of maintenance. How would you pay maintenance to a spouse residing in India if the other spouse is residing abroad? This is a very debatable question. Courts have now started adopting the principle that it is a means-based maintenance, be it temporary maintenance, be it alimony, and the spouse, left behind spouse or the spouse who is to be paid maintenance or alimony, should be paid on the basis of the income of the earning spouse, the life standard which the other spouse lives with, so the other spouse is also entitled to it. And therefore, even if compensation is to be granted in dollars or sterling, the equivalent should be taken and it should be apportioned to the spouse in the situation in which it is. Now, another very emerging issue which is coming up in the matrimonial arena is domestic violence. It is very popular now that marriages which are solemnized in India and parties relocate to too often, the marriage is not workable, marriage breaks up, one of the spouses returns, initiates proceeding under IPC 406, 498A. 406 is matrimonial cruelty, 498A, 405, 406, I'm sorry, is breach of trust, 498 is a matrimonial cruelty. Along with it, are also involved in proceeding under the Domestic Violence Act. Now, the moot question which comes is, if offences have taken place abroad, would the Indian courts have jurisdiction? Now, vis-a-vis IPC, there is a judgment of the Supreme Court that the provisions of IPC do not apply extraterritorially. Now, likewise, the question which is not yet settled by the Supreme Court but may arise one day is, if there is domestic violence suffered in Canada, in Cape Town, in London, or in America, can that be a subject of a domestic violence petition at the place within the territorial jurisdiction of where the agreed spouse resides? Now, Section 27 of the Domestic Violence Act confers jurisdiction upon the magistrate where the spouse is living to take cognizance of a complaint in regards to domestic violence. But then the question is, will the Domestic Violence Act have extraterritorial application? Obviously no, but the provision of Section 27 empowers the magistrate to go through. I have been faced with a situation where in the IPC I was able to convince that the IPC does not have application abroad. But in the Domestic Violence Act, the judge says I have jurisdiction. So the question remains a grey area and may perhaps get settled with time. So with this, we move on to issues of maintenance, more issues of maintenance in matrimonial matters, and financial proceeding which can be initiated by the wife. Now friends, just for your information, if there is an agreed spouse on Indian soil, you can invoke 125 for maintenance. You can invoke Section 24 for maintenance in the Hindu Marriage Act as an ancillary clause. You can invoke a right of residence and other relief under the Domestic Violence Act, and you can do all of them simultaneously. The grant of a quantum of maintenance may vary depending on maintenance granted in another legislation, but the fact of the matter is you are entitled to invoke the jurisdiction of all these courts simultaneously, and there is no bar on the jurisdiction of one court or the other. Then comes the question of enforcement of matrimonial judgments. Now, suppose you have a judgment of a matrimonial court of a foreign jurisdiction. Would it apply in India? The principles which guide us from that perspective is Section 13 and 14 of the Civil Procedure Code as to when foreign judgments are inclusive. The provisions, the Section 13 lays down the grounds under which the maintenance, under which the judgment has to fall within the parameters of Indian law. It should not be opposed to principles of natural justice. It should not be opposed to the principles, opposed to the grounds available under Indian law, etc., etc. And Section 14 says that whenever a copy of certified copy of foreign judgment is used, it shall be conclusive proof of mistakes. Now, the question of the foreign court judgment being tested would be a question which will be seen on the basis of the judgment and the contents depending on the ground of divorce. For example, if a foreign court has dissolved a marriage on the ground of irretrievable breakdown, it is straight away not applicable in India because irretrievable breakdown as a ground for divorce is not a ground for divorce under Section 13 of the Hindu Marriage Act or under the Special Marriage Act. The Supreme Court does use Article 142 to do complete justice and use it to break down, but that is an exclusive jurisdiction of the Supreme Court. And under Sections 13 and 14, irretrievable breakdown will knock down a foreign judgment seeking divorce on the grounds of irretrievable breakdown. Now, an emerging jurisprudence which has wavered in courts from time to time is child custody, guardianship, issues in marriages solemnized in India between two Hindus or in Hindu or a person of foreign nationality, which are normally known as mixed marriages. Now, friends, interparental child removal within India or inter-country child removal from one country to another country is not a ground for divorce. Sorry, is not a recognized wrong or an offense in the Indian jurisprudence. So, if one parent removes a child from the custody of another parent without his consent or violating a court order in a foreign jurisdiction, it is not regarded as a wrong or an offense in the Indian jurisprudence or in the Indian statutory regime. The reason for this is that, insofar as Hindus are concerned, Section 6 of the Hindu Minority and Guardianship Act says that the natural guardian of a child shall be the father and after him the mother. Gita Hariyan's case late by the Supreme Court says they are both equal. So, father and then the mother are natural guardians, provided that the custody of a child less than 5 years of age shall ordinarily be with the mother. So, in the Indian system of law, once a parent is a natural guardian, the question of a parent committing a wrong by removing a child from the custody of another is not considered to be wrong, offensive, or in any way violating any law. Now, to put the picture in a larger perspective, in the realm of private international law, there is a convention of the Hague Conference of Private International Law based at Netherlands, and the Hague Convention on Civil Aspects of International Child Abduction in 1918 is an international convention which has been signed by 100 countries. India is not a signatory to it. And in this convention of the Hague, though the title of the convention uses the word abduction, but insofar the content of the convention is concerned, interparental child removal has a civil connotation. It does not use the connotation of criminal jurisprudence insofar the word abduction is concerned. So it simply says that the willful removal or neglect with removal of a child without the consent of the other, violating the rights of the other's parent, and not permitting him to take any decisions regarding the welfare of the child amounts to interparental child removal. So this is the international definition, and under the Hague Convention, once you sign the convention, you make an enabling law within your domestic jurisprudence to give teeth to the convention, and once you do that, you create a body known as a statutory authority or an administrative body who will communicate with the statutory authority of another country to initiate a process for return of children. Now, we have been talking of signing the convention for the past 20 years, but we have not yet signed it. I was an amicus to our High Court for 12 long years in respect of a child removed from India to England, wherein the child could not be located. An aunt had removed the child from the custody of the parents. Despite CBI being appointed, despite efforts being made to recover the custody of the child from England, we failed. So ultimately, the matter was referred through the judgment and my report to the Law Commission. The Law Commission came out with a recommendation, and the Government of India enacted an Inter-Country Parental Child Removal Bill, which the Ministry of Women and Child Development referred to a select committee called the Hague Committee, which was headed by Justice Anil of our court. 6 honorable judges, 6 government officers, including myself, were a part of that committee. We spent over a year. We have given a 2-volume report, and we have suggested to the government to make a bill and to define interparental child removal and to constitute a system whereby we can adapt to the principles of the Hague Convention and thereafter take a decision whether we want to sign the Hague Convention or whether we want to statutorily come into the fold of providing a remedy within our system. Now, in this context, the current scenario of handling an interparental child removal matter is very, very grave. The only remedy which is efficacious, speedy, and effective is a writ of habeas corpus. A writ of habeas corpus under Article 226 for the High Court or a writ of habeas corpus for the Supreme Court under Article 32 is the fastest remedy, but it is a difficult remedy, for you have to convince the court that it is acting as parents portray the best interest and welfare of the child to exercise its jurisdiction. Friends, habeas corpus, when it pertains to a child, is not used in the context of illegal detention. It is used in the context of the welfare of the child. And we go back to the Supreme Court decision of Gohar Begum in 1960 and Neil Ratan Kuddu in 2011, where the court has said that following English and American law, we use this jurisdiction under the habeas corpus writ for the welfare of the child in a parent's particular jurisdiction. Now, if the matter can be resolved by exercise of summary jurisdiction, the matter is settled and a spouse is told to go back to the children, with the children, to the country to which they belong and from where they came. But if it requires evidence or there is a detailed discussion needed by way of evidence, proof, then the matter is relegated to the family court or the guardian judge under the Guardian and Wards Act. Now this brings us to an archaic law, the Guardian and Wards Act 1890, a 130-year-old law, whereby a natural parent is constrained to invoke the jurisdiction of the family court or the guardian judge, even though he or she is the natural parent. And in such a petition, the parent seeks exclusive custody or custody only for himself to the exclusion of the other parent. Now, this outmoded remedy has outlived its utility. The Law Commission has seriously, Justice A.P. Shah, as chairman of the Law Commission, has seriously recommended an overhauling of the Guardian and Wards Act, amendment of the Hindu Minority and Guardianship Act to put a system in place. Now, surprisingly, the Hindu Minority and Guardianship Act contains no provision by which you can invoke the jurisdiction of a court to take custody of your child. So, a natural parent has to use SMGA, dead with GWA, to go to a family court and seek exclusive custody. Now, in the realm of private international law, the concept of single parenting, the concept of singular custody, the concept of excluding the other parent is now considered to be detrimental to the welfare of the child. The Supreme Court now, in Peri Kesindra, in Lahari Sakhamuri, in Jashita Sahu, is talking of things like parenting plans, is talking of joint parenting, is talking of shared custody, is talking of parents with equal rights. And the Section 6 of the Hindu Minority and Guardianship Act, whereby there is a gender preference in Lahari Sakhamuri, has been diluted. And it is no longer the principle that if the child is of tender years of age, the mother or the father shall have exclusive custody. But friends, this is an area in which the law is yet to evolve in the shape of legislation. The matter is still developing through the jurisprudence of the courts only. So till we sign the Hague Convention, or if we don't sign the Hague Convention, till we make an enabling law, what is the way forward? I have worked on a matter for 3 years, in which 2 children belonging to a couple of Sikh origin, but of both US nationals, there was a bit of fight on custody of the children. One child was of US nationality, born in USA. Second child was born in India. Now, the child born in India could not get Indian nationality because underneath Citizenship Act, only if one of your parents is an Indian national can you be given an Indian nationality. So since both the parents had US passports, even though they were of Indian origin, the child had to get a US passport. So long as the matter went on for good 2 years plus, the child was stateless. The child had no passport, the child had no nationality because the mother did not want her to take a US passport. She did not apply for one and she did not qualify for getting an Indian passport because the child was born, even though in India, but to US parents. Now, the mother invoked the jurisdiction of the family court in Delhi, and the father took a preliminary objection that the matter could not be agitated. And in an application under Order 7, Rule 11, that is to decide a preliminary issue, saved the jurisdiction of the court under Section 9 of the Guardian Rewards Act. Now, this is another serious issue which a parent faces, that the guardian judge or the family court's jurisdiction can be waived in the child custody petition. Under the Guardian Rewards Act, only if the minor ordinarily resides in the jurisdiction of the court. Now, there are judgments to say that ordinarily reside means habitual and continual residence, not residence on the date of the application or residence immediately before the filing of the petition, or residing in a jurisdiction where one parent is set up to be removed. This is very relevant in the cases of inter-country, inter-parental child removal. So I succeeded in telling the court that the court had no jurisdiction. The matter went to the High Court and the High Court affirmed the decision. Meanwhile, the father invoked the jurisdiction of the US court and he got an emergency custody order for the mother to return to the children and the father being given interim custody. I sought the implementation of this order in the High Court of Delhi, and the High Court of Delhi passed an order that the mother should go back with the children but impose conditions. That is, the mother will not be separated from the children. The father will be allowed access, visitation, and joint custody. The father will provide for the mother for a period of 2 years or till she goes back to work. They will get their matter resolved in the court in the US. They were both in the medical profession and in a joint practice. Now, all these conditions were put as protections, and I was told that I will not invoke prosecution because in the US, child abduction is a federal offense. Now, in effect, the Delhi High Court wanted me to go back to the US and get the US court order modified, whereby the custody granted to me was to be changed to the way Delhi High Court wanted it. And I was supposed to bring the amended US court order to Delhi for further action. Now this, friends, in the parlance of private international law is called mirror order jurisprudence. It is very common abroad, but in India we don't follow mirror orders. Mirror order basically means an order passed in one jurisdiction reflects in another jurisdiction and is implemented without going behind the order. Now, after I produced the order of the US court modified as the Delhi High Court wanted it, the mother still did not go back and she went to the Supreme Court. Meanwhile, interestingly, the family court order on lack of jurisdiction found favor with the Supreme Court, and the Supreme Court said that the welfare of a child could not have been determined by the family court in an application for jurisdiction challenge. So I was remanded to a full trial to be done in 6 months on the welfare of the children. So we went back to the family court while the habeas corpus petition got decided. The Supreme Court allowed both to go on. The family court did a trial in 6 months, and the family court came to the conclusion that the children needed both the parents. The family court looked at parental allegations. The talked of welfare of the children, it talked of joint custody, and it said the mother should go back. This order was challenged in the High Court. The High Court affirmed it. Meanwhile, the habeas corpus order and the family court order on merits both landed in the Supreme Court. And in February 2020, the Supreme Court bench of Justice Lalit and Justice Malhotra prevailed over the parties to sit down in chambers, and they drew up a plan, again in the shape of the mirror order conditions of the Delhi High Court. And it was agreed that the parties shall go back and the children should go back with the mother. But it was quite difficult because by the time the permissions came, the US passports were made and clearances were given, the pandemic came and the children are sadly still in Delhi. So friends, this is the long story of the mirror order jurisprudence and the welfare of the children and the concept in which it goes. Now, very quickly to run down on the law. We have the judgment of Surinder Kaur in 1984 where Supreme Court says children should go back to the country of their habitual residence. But then, in Narasimha Rao's case, things change and the Supreme Court says no, foreign court order will be one consideration only. Then we graduate to the judgment of the Supreme Court in the case of Aarti Bandi. Taking the matter, the Supreme Court again reiterated that the children should go back. Then there was a celebrated judgment by Justice Kapoor and Surya Vadanan where the Supreme Court laid down three principles: theory of first strike, principle of jurisdiction of closest contact, and the principle of comity of courts. So essentially what the Supreme Court did, it laid down practice directions. Something like what happened in Vishakha on sexual harassment in workplaces, and in 15 years it became a law. So this is another vibrating resonance of jurisprudence in our system, particularly in private international law, that the court steps in to aid and assist in the enactment of some guidelines till a law comes into place. So the Supreme Court said whichever jurisdiction takes control first strike will decide. The jurisdiction which has the closest contact will take over. And the comity of courts principle means essentially that two jurisdictions will respect each other's law. This is an elementary principle of the private international law jurisprudence. Now this judgment subsequently in Nityanand Raghavan, Kanika Goyal was modified, and the Supreme Court did away with the principle of first strike and the principle of first contact, theory of first contact, and said welfare of the children will be paramount, foreign court order will be one consideration. But the doctrine of jurisdiction of closest contact, which came from 1984, Justice Chandrachud's judgment, still holds good. And the Supreme Court said a summary inquiry or a detailed inquiry to determine welfare, and the jurisdiction of closest contact thereafter to decide the welfare of the child at length. This is the principle also followed in Navtej Singh's case, which I contested. But subsequently in Lahari Sakhamuri, the Supreme Court came out more clearly. And very recently in Yashita Sahu, it has further been made clearer, where the Supreme Court has gone to the extent of saying the welfare of the children lies in going back to the jurisdiction in which they have the closest contact. If the mother does not wish to go back, she can hand over the children, but if she goes back, she gets the protections and so on and so forth. So this, friends, is the development of a complete jurisprudence on child custody law in the realm of private international law, and it is a very continually developing jurisdiction. And you will find a lot of litigation in this area because it is very common for foreign courts to not let children come to India for the simple reason that a court fears that if a child goes to India, since India is not a signatory to the Hague Convention on Child Abduction, So therefore, India will not return the child. But I have started using another convention of the United Nations which India has signed, and that is the United Nations Convention on the Rights of the Child, popularly known as UNCRC. Now, this convention was acceded to by India in 1992, and India, after signing this convention, made a number of changes in its laws. The principal change is that the Juvenile Justice Act of 2000 was brought in after its existence as it was in 86, and further in 2015, Juvenile Justice Care and Protection of Children Act has incorporated all the provisions of the the United Nations Convention on the Rights of the Child, which in principle are talking of the right of the child to a home, the right of a child to a nationality, the right of a child to be returned to his country of his jurisdiction, the right of a child to be care and love of both of his parents, and so on and so forth. Now, the definition of the best interest of the child, which is in the UNCRC, has been put in section 2, subsection 15 of the Juvenile Justice Act. And the best interest in the welfare of the children has been defined. The courts were reluctant to take on this definition on the ground that the JJ Act is an act which applies to children in conflict with law or children in need of care and protection. In my successive matters before Delhi High Court, I was able to prevail over the court that since it is a child-friendly law, it is meant for the welfare of the child, and a child who is removed by one parent is a child who is in need of care and protection. The definition of the best interest of the child, which does not exist in any other law, more so the Hindu Minority and Guardianship Act or the Family Courts Act or the Guardian and Wards Act. So therefore, section 215, defining the best interest of the child in the JJ Act, should be put in principle. And in Lahari Sakhamuli and in just Navdev Singh, this judgment has actually been taken in. And this is something for you as students or learners of private international law to see that when India signed the Hague Convention or any other international convention, it is per se obligatory on the part of Indian courts to implement the provisions of the legislation. We saw this in ABC versus State, where an unwed mother wanted a birth certificate of her child, minus the name of the father, whose name she knew but she did not want to put on the birth certificate for the reasons of privacy of both the parties. And the Supreme Court, Justice Vikunjit Sen, has expounded the United Nations Convention on the Rights of the Child to say that the rights of the child for a birth certificate cannot be done away with. And this was done by importing the provisions of the UNCRC and other international conventions on the right of the women also, CEDAW being particularly one of them. Now, another very contested issue is what is the status of child custody orders obtained under the Domestic Violence Act. Now, under the Domestic Violence Act, you can obtain a protection order, you can obtain a right of residence, you can obtain monetary aid, but you can also get child custody orders. Is a child custody order under the Domestic Violence Act in international terms a good order? Does it supersede the child custody orders under the Guardian and Wards Act or under the personal law of the parties? No. The child custody order obtained under the Domestic Violence Act for a foreign jurisdiction, I have opined, does not have the effect as it would if there is a court order from the guardian judge or the family court. Now, friends, with this, we move on to the enforceability of foreign court orders and orders regarding effectiveness insofar securing the return of a child is concerned. Now, this is another very developing area where a foreign court, knowing the acrimony of bitterness between spouses, is at times reluctant to transfer a child to India temporarily for the simple reason that the child will not be returned. So, in the absence of a mirror or a jurisprudence being made applicable by an Indian court, what are the remedies? Now, the first proposition put forth by a foreign court is, I am sending the child back to India temporarily to visit grandparents, family, or other relatives. I am passing an order. Will India mirror this order? I answered no. And the court says, what are the remedies? So we can draw up an agreement, we can have sureties, we can have reporting to the embassy, we can have contact, etc., and so on and so forth. So these are possible remedies to see that foreign court custody orders can be implemented or the custody of children can be taken back to Indian foreign jurisdiction if so desired. Friends, with this we move on to the next issue, which is again a very developing area in terms of children is concerned, and that is adoptions. Now, India has 12 million plus orphan children who are in children's homes, in juvenile homes, or in foster care, or waiting to be adopted. Inter-country adoptions did not have any law. So Lakshmikant Pandey's judgment by the Supreme Court in 84, 86 and 88, three successive judgments, led to evolution of the law, which is now the Adoption Regulations 2017. Now this is again a principle of practice directions emerging from the court and going into legislation. India was a hub for removal of children illegally, and children were sold, children were used for immoral purposes, children were trafficked. So the Supreme Court, seeing to the rampant abuse of children, came up with the three judgments in Lakshmikant Pandey, and ultimately the Juvenile Justice Act 2000 and 2015 brought in special provisions pertaining to adoptions. So the Juvenile Justice Act 2015 now specifically talks of rehabilitation of children. And in the international context, adoptions, which was a big racket, are now under the control of Central Adoption Resource Authority, CARA for short. Central Adoption Resource Authority was previously known as Central Adoption Resource Agency. So from an administrative body, it is now statutory authority, and all inter-country adoptions are streamlined through CARA. So every prospective parent applies to the central authority in its country, and that central authority forwards the application to CARA as central authority in India, and this happens all under the Adoption Convention of 1993, which India signed. Now, there is a United Nations Convention on Adoption of Children, which India has signed, and because of India signing this convention, India is obligated to create what is known as a central authority, and under the JJ Act of 2015, CARA has been designated as the central authority, which means CARA entertains all applications, CARA sends out all applications for adoptions, inter-country adoption of children, and after this process of both countries is completed, the child is given an NOC by CARA, the court order is also obtained. There is a total change of procedure. The adoptive parents and the parents giving an adoption are all parties, or if the parents are not there, the adoption agency, the adoptive parties are parents. There is no list. There is no public notice. So the complete procedure under the guardian and what that insofar custody is concerned is done away with. And by a summary procedure, after an NOC from Dhara and a court order, the child is allowed to leave the country and go to the adoptive parents in the foreign jurisdiction. So there is a complete machinery available for inter-country adoptions insofar as the JJ Act is concerned. But then the looming question is, as I had started in the beginning with part of nationality and citizenship, if there is a adoption under the Hindu Adoption and Maintenance Act by parents of Hindu religion, and the parents giving an adoption and taking an adoption are both Hindus by religion, then would Kara come in? For your understanding, as far as Hama is concerned, giving and taking is enough. There is no deed, there is no registration, there is no Kara, there is no process, which is because if you fulfill the conditions described of giving and taking an adoption and the child to be adopted qualifies for being adopted, Hama is a self-contained code, and the parents who are giving and the parents who are taking take care of all those precautions which Kara does as a body under the JJ Act and statute. But then, under the adoption convention, until and unless Kara gives an NOC as a statutory authority, the child will not get a visa to leave the country. And there is an obligation under the adoption convention that the central authority must give an NOC for every inter-country adoption, be it between relatives or be it of orphan, abandoned or surrendered children. Now, I am an amicus in this matter. This is going to be heard next week in our High Court. And the question is, should the JJ Act be applied to such a instance? Now, Section 56(3) of the JJ Act says that adoption under Hama, the provisions of inter-country adoption shall not apply. But then, the JJ Act also says that in all inter-country adoptions, an NOC by Kara is no must. So how do you reconcile this? In my report, I have suggested to the court that the Adoption Convention of 1993 contains provisions of exemption and recognition insofar domestic adoption are concerned. So if by a domestic law there is an adoption that is exempt from the provisions of the convention, and under the Adoption Convention, there is a provision that domestic adoption will be recognized. So in my report to the court, I have suggested that this process of recognition and exemption should be made applicable to the adoption by the Hindu parents giving to Hindu parents, to adoptive parents who are of British nationality and who want to take the child to UK. And Kara should give an NOC invoking the provisions of the convention, but not applying the procedure and tests, because that will in a sense mean duplication of the entire procedure which Hama has independently created.
Hello ma'am.
So the vote question
Please
is,
tell me your mail ID.
if there is a personal law of adoptions applicable where parents are giving and taking,
SUGA.
would the provisions of the JJ Act step in to rule over again or examine the whole thing again?
SUGAN.
In my view, no, but I still wait for the court to take a call on this issue. And the matter will ultimately obviously go to the Supreme Court. But this is an issue which will need resolution. There is a very enlightening judgment of the Kerala High Court
Ma'am, we have not
2020
received your
in the case
mail.
of domestic adoption, where the local child welfare committee removed the child from the custody of the adoptive parent, saying this child had been given and taken in adoption without the permission of the Kara
No, we have not
and without
received your
following the procedure. The Kerala High Court held
Sugan Sundaramatta? Once
that
again.
this is the adoption under
Sugan
Hama.
Sundaramatta?
There is a registered deed of adoption, and under Hama,
Sugan
there should be
Sundaram
a
dot
presumption that the
Suganyan
deeds
at
contained should be
gmail.com.
accepted, and
Once
therefore,
again, once again.
JJ Act will not apply. It is adoption under Hama is irreversible,
Sugan
and
Sundaram
therefore,
dot
the Child Welfare
So
Committee
then
was
here,
directed to return the child and
SUKA,
cancel the FIR which had
SUGANYA dot
been lodged. Because under VJ Act, any done outside Kara, the bypass the procedure of
right?
VJ Act invites criminal prosecution under Section
Wait a
80.
minute, yeah.
This has been a very enlightening view, and it has opened up the arena in
No.
interpreting the question. But the question will be, the other question will be, how will the issue come up in inter-country adoptions, which is the matter in which I am assisting. The Supreme Court did talk of under the Act of 2000, Act of 2000, in the case of Malhotra,
Ma'am, this is already sent yesterday.
and in inter-country
But
adoptions
anyway,
by
we are sending
parents
it again.
and
Okay.
adoptive parents,
Okay, you
JJ
just
Act will
go
not
to
apply.
Google Meet and I will
But
give
that
you the
was
code. You just go enter.
2000
Okay.
Act. There is also a judgment of
It
the
is
Delhi
already
High
sent,
Court,
ma'am.
which is
What-
again re-amendment position.
In
So
the
there is
morning
no
you send
Supreme
the
Court
reminder
judgment
also, ma'am.
clearly abiding on the principles. So we have yet to see how the adoption convention will be reconciled with Hama, and ultimately this is going to be an important landmark area in which law will develop in the domain of private international law. Now, friends, there is another very new concept which has come, and that is surrogacy. Now, surrogacy, I would put it as a baby of private international law, which has been born but which has not grown. Surrogacy started in India through the guidelines of the ICMR in the year 2005. Now, surrogacy became a multi-billion-dollar industry with thriving hubs in Gujarat
ഇത് ഇപ്പൊ വായിക്കുവേ ഇത്
and some part of North India and some parts of Maharashtra as well, whereby surrogate mothers gave birth to children on behalf of adoptive parents who were mostly non-resident Indians or foreigners. And baby Manji Yamda's case, which is the only decided case by the Supreme Court in a summary way of a Japanese couple, is the case in which the Supreme Court says that there are baby farms and exploitation and a law needs to be put in place. Baby Manji Yamda's case was a Japanese couple commissioning an Indian surrogate to give birth to their child. When the child was born, the couple was divorced, so the father came to take custody of the child. Meanwhile, the High Court dealt with the matter on the asking of an adoption agency and took the child away. The father came to the Supreme Court through his mother because as a father of a girl child, he could not be given custody. So the Supreme Court passed a special order asking the government of India to resolve the matter by giving her an identity certificate. The question was, what nationality, whose parentage? Because the High Court apparently had issued an Indian birth certificate to the child. So a summary procedure was adopted and the child was sent back. Then came the case of Jan Balas, where the Gujarat High Court gave Indian birth certificates to two German children, twin children born to a German couple. And the government of India came up in and said these children cannot be given birth certificates in India because they are foreign nationals. Their parents are German. So again, the matter is pending before the Supreme Court, but the Supreme Court allowed the children to leave with the German parents by giving them temporary exit visas. The issue still remains unresolved. So friends, surrogacy developed as a medical practice through the ICMR guidelines which prohibited surrogacy. Slowly, different bills came, 2000, 2004, 2005, 2012, 2014, and ultimately 2019. So there is a surrogacy regulation bill and there is another surrogacy bill which are hand in hand. One talks of creating a machinery and the other talks of regulating surrogacy. Till 2012, surrogacy was permitted to foreign nationals, single persons, persons of foreign origin. But in 2012, all of a sudden, the government of India came up with administrative guidelines restricting surrogacy to NRIs, PIOs of Indian origin and excluding foreigners totally. Single parents were also excluded. I happen to challenge this on the behalf of the Sudanese national single parent to say that there is an anomaly. Now, under the adoption regulations, adoption is permissible to persons irrespective of marital status and to single persons, irrespective of nationality, residence, citizenship, or religion. So, if the ultimate aim is parenthood, be it surrogacy or be it adoption, can you take over the right of procreation, that is the right to life, or part of right to life and liberty, and infringe of fundamental rights? Now, as you know, Article 14 and Article 21 is available to persons. Article 19 is available to citizens. So, as a foreign national, I can invoke the jurisdiction to say that my right under Article 21 of right to life is taken. The question remained undecided because the government had not yet come out with a bill. Justice Sunny Mission Call decided the matter and said, as and when a law is changed, this will be taken. But slowly the bills moved up, and in the 2019 bill, surrogacy was restricted to infertile Indian couples with 5 years of marriage, proven infidelity, and a surrogate could be only a close relative. So, in this situation, there was an outcry that this is too restrictive, confining it to Indian couples, proven infidelity, close relative as a surrogate. So it became a very grey area and hotly contested. So the matter was referred to a parliamentary committee. It was referred to a parliamentary committee, and a 21-member parliamentary committee came out with recommendations, and they have watered down the condition of the period of marriage, valid for 5 years. Proven infidelity has been watered down to a medical certificate, but still, foreigners are banned, OCIs and NRIs have been permitted. But the question remains, why should I be asked to get a certificate that I am infertile? Is it a right of my privacy? Seeing the 9-judge constitution bench judgment on the right to privacy, why must I get a certificate that I am unable to procreate? The question will come when the bill is made an act. It's a bill of 2020. And the moot question again, if adoption is permissible to parents, irrespective of marital status, irrespective of religion, and irrespective of nationality, why should surrogacy be confined only to Indians? Meaning, if there is a foreigner wanting a surrogacy process in India, why should he be debarred? This again will remain a question to be decided as and when challenged. The issue is, if we are going to ban surrogacy, why do we not think of legalizing surrogacy and creating a law in place as we did in the adoptions? Create another body like CARA as a central authority, regulate it, put conditions, do home study, instead of closing the door, make a window, do a processing, check people who want to do surrogacy like you do in adoptions. Maybe when the law is challenged, another law is suggested, things may come in place, and and issues may arise. So, friends, surrogacy is again an area exponentially in the domain of private international law. And the larger question which the Hague Conference of Private International Law is looking at is how will we handle surrogacy? Because surrogacy involves international issues, nationality, citizenship, parentage, rights in countries to which their parents belong, and unless and until there is an international convention or there is an international law in place, it will be very difficult to moderate, to comprehend, and to balance different domestic legislation in surrogacy. So an international surrogacy law or an international convention on surrogacy, the Hague is already on a project on it, may be needed, whereby countries may be able to share issues on surrogacy. As of now, surrogacy is permissible only in the US and certain other parts of the world. In Europe, it does not agree because the church opposes it, and most of the systems do not agree of a surrogate mother giving birth to children. So most of Europe doesn't allow surrogacy as a law process itself. Then moving on to another interesting area is succession. Now, overseas Indians migrate, but they leave behind property, and sometimes very valuable property, maybe agricultural, maybe industrial, maybe domestic, which becomes a bone of contention when succession has to take place. How do you succeed to the property of an NRI? What law will apply? How many wills should he make if he is living abroad? And will the concept of domicile apply? Most countries still have a provision of inheritance tax. United States duty, we abolished it. Now, people do try to avoid inheritance tax or tax on debt, business property, by saying that Indian law will apply. And the principle which emerges from judgment says that insofar your movables and removals in India are concerned, they will be governed by India. And insofar your movables and removals in a foreign jurisdiction are concerned, they will be governed by the law of the country in which your property is situated. So this is the fundamental principle which I opine on in issues whenever they arise. But the question which sometimes comes is, if I have taken a nationality of a foreign jurisdiction, do I still retain my domicile in India? Now, there is an interpretation that if I do not sell my property, I retain my property, I keep it in my name, I pay taxes regularly, I maintain in contract, I do retain my domicile, and when the issue comes insofar taxation is concerned in a foreign jurisdiction, I can avoid the incidence of taxation to say that my domicile is India, so I will be governed by my law of domicile. This is again a concept of private international law, which is used popularly to take benefit of laws which are more favorable to you. Now, insofar wills is concerned, if you have properties in multiple jurisdictions, the best thing to do is to make wills in different jurisdictions. In India, you are governed by the Indian Succession Act. You can make a written will, have it witnessed by two people. Registration is not compulsory, but if you register a will, it helps to prove the will. And your Indian will can govern your Indian property. You can obtain a succession certificate for movables, you can obtain a probate for removals, and you can succeed to the property accordingly. So this is broadly how testamentary succession takes place. You do not make a will, then the Succession Act, the Hindu Succession Act takes over, and the property goes to your natural heirs, class 1, class 2, as the Hindu Succession Act would say. Friends, with this we move on to another area which is now going to be very hotly an issue in the domain of private international law, and this is anti-suit injunctions. But let us first understand what are anti-suit injunctions. When you are in a litigation in a foreign country and in India on the same subject matter between the same parties, the preferential jurisdiction, which is the most convenient forum, following the principle of forum convenience, is the jurisdiction which will have the jurisdiction and authority to adjudicate the matter. This was a principle which in Modi Entertainment very well expounded as a commercial matter, but is now becoming extremely popular in matrimony. So you have two spouses litigating, say in Australia, say in Canada, say in London, and also litigating, say in India. The question is, which divorce petition in which country will prevail? Which child custody petition in which of the two jurisdictions will prevail? So parties are same, matrimonial cause is same, children are same. So applying the principles of forum convenience and the principles laid down in Modi Entertainment by the Supreme Court, the court, which is first seized of the matter, is more convenient, has all the subject matter of the litigation before it, is considered to be the preferential jurisdiction. Now, that court, when adjudicating the matter, cannot stop another court of another country to decide the matter, because that court is governed by the system of that country. So you move an anti-suit. It is a separate litigation. It is a separate suit. It is recognized under the family courts as a suit or an order for an injunction, and there is a separate jurisdiction for an anti-suit injunction under the Family Courts Act. You move an anti-injunction suit, say in the family court at Mumbai, say in the family court at Kochi, to say that so-and-so party appearing before this court in so-and-so litigation is also litigating on the same cause of action, the same marriage, same children in New York, London, Australia, and this party should be injuncted or stopped from litigating in that court. Thereby, the court, say in India, will grant an anti-suit injunction to stop the jurisdiction in that country, stop the party in that country from going further with the proceeding. The court cannot stop that court, but the court can stop the party before it and also before the foreign court to say you are restrained, you are estoppel law, as in the principle of estoppel under the Evidence Act, to proceed with the litigation in that jurisdiction from going ahead with the litigation. Now, if a party does go ahead with the litigation and still defies it and continues in the foreign jurisdiction, the Supreme Court says this is a matter which is violative of law, contempt of court can be initiated, but then ultimately when the foreign court decrees not to be executed in India, you can raise an objection that this was obtained contrary to law because there was an anti-suit injunction. Now, anti-suit injunctions are becoming popular. Now, with contact becoming difficult, travel becoming difficult in COVID times, I have recently opined 2 or 3 matters whereby anti-suit injunctions have been granted by family courts in matrimonial petitions without an anti-suit injunction prayer or without even an anti-suit injunction petition separately. The question is, can this be done? No. You have to plead separately in a separate suit, in a separate petition. How you claim the lead anti-suit? How do you satisfy the test of Modi Entertainment and the Supreme Court? How do you satisfy the principle of foreign convenience? And it's only upon the court being satisfied that the court can pass a detailed order. So if there is an ex parte order issuing notice of granting child custody and also passing an anti-suit injunction, that per se would not be an order which a foreign court can take note of. I gave an opinion recently, another lawyer gave a different opinion saying, unless this anti-suit is vacated, the Australian court cannot move on. I said the anti-suit process is not being initiated. And another very important fact is that the relief which you are claiming, let us say settlement of matrimonial property, is common in both jurisdictions. So even a divorce petition in India, you have not claimed settlement of matrimonial property, which you may have claimed in a foreign jurisdiction separately. Now in foreign jurisdiction, you can claim child custody, you can claim settlement of matrimonial property independently of a divorce petition. In India, we cannot. Child custody you can, but settlement of matrimonial property is a part of the Hindu Marriage Act divorce petition, which means settlement of matrimonial property cannot be done in the matter of divorce petitions because disposal of property under Section 27 is an ancillary relief, not a principal. So if the Australian court is seized of settlement of matrimonial property, which is not a subject pending in a divorce petition or even agitated or raised in a separate anti-suit, and an anti-suit order is passed, that would be a questionable issue. And now in view of the latest judgment of the Supreme Court, saying that there is concurrent jurisdiction and anti-suit injunction should be declined, it remains a grey area. But again, jurisprudence has to develop and the principles of law will evolve to see how this goes. Now this brings me to the last part of what I want to say is real justice in virtual courts. How are we going to implement child rights? How are we going to agitate matters in family courts? How will we decide custody petitions? Now the Delhi High Court has drawn up an action plan. Delhi has 5 family courts. Delhi territorially is divided into 5 jurisdictions where there are civil and criminal courts, and in every civil and criminal court building there is a separate family court building. So Delhi is a huge territory, so the Justice Hema Kohli of the first female judge of the Delhi High Court has drawn up an action plan whereby she has taken all the family court judges into confidence and asked them to take up matters by video conferencing, telephonic hearings, or whatever possible limited contacts is available, by trying to settle matters and get moving. Commercial matters can wait, civil disputes can wait, but family court issues cannot wait. If there are, let us say, child custody issues, there was a very recent matter before the Delhi High Court recently in which 3 girl children were in custody. The mother wanted contact. Civil movement was not possible in the early days of COVID. So the Delhi High Court said that internet-aided people will be available to all 3 children in a room to be in contact with their mother whenever they want. The door shut but not open in the house. Now this was an innovation which the court devised. Now even in terms of foreign court orders, we will now perhaps have to evolve the mirror on the jurisprudence. As a contemporary developing thought, implement rights of parties whereby orders are issued in one court but sought to be implemented in another court. So if the children are in the custody of a parent, let us say in India, and the foreign court passes an order, the foreign parent cannot come to India because of the travel restrictions and international movement. So how will we implement the foreign court order? There has to be some principle in agreement whereby family courts will have to evolve some methods, or the High Court or the Supreme Court may have to come up with something whereby we will need to settle rights of parties by mutual agreement, and the comity of courts principle will have to be revived, particularly in child custody matters. Recently, the Supreme Court granted divorce by mutual consent in a transfer petition where parties were trying to resolve the matter. So the Supreme Court used 142 to consent of parties and right 13B and dissolve the marriage. So maybe issues like this. So in a process of virtual hearings, in a process of virtual courts, we will have to do real justice because the issues of children and parties and parents cannot wait. Concepts like joint parenting, shared custody, parental alienation syndrome, suffering of children, we have to evolve, we have to grow. Family law is a poor country cousin and things have not really developed. William Wordsworth, in his poem, talks of, in my heart leaps up, talks of child as the father of man. In the poem Rainbow. So children should not wait, children ought to wait. And Lord Tennyson, in his poem In Memoriam, talks of an infant crying in the night, an infant crying for the light, and no language but a cry. How do we silence the cry? How do we lead to the cry? How do we resolve the cry? See, children are very innocent, and child rights jurisprudence is very important. Adults are just outdated children, and children make your life important. In this perspective, anyone who makes anything to help a child is a hero to me. And children see magic because they look at it. So when there are spaces, there has to be togetherness. And children are the hands by which we take hold of when we have to go to heaven. So it is in this perspective, friends, that private international law is now a law which is probably going to be a bigger challenge for evolving statute. Until such time statute comes in position, honorable judges like Justice Mustaque will enlighten us with their vast views and helpful relief which they can call out in different jurisdictions. So with this quick rundown on the entire summary of private international law in whatever 1 hour I could put across, I now leave the floor open for anybody who has any question on any of the issues relating to the subjects I have discussed. Thank you.
Thank you, sir. As sir has said, the floor is now open for questions. So I request you to kindly unmute and ask questions one by one.
Can we ask him?
Yes, you may ask in the chat box.
Please read out your question. I am actually not on the screen. So I am
Yes, I'll read out the questions.
Yeah,
I'll read out.
I am on an Apple phone. Because there is
Yes, sir. Yes, I'll read out the questions. So if any of you have questions, please put it in the chat box. The floor is open for questions. So there's a question. This question is, what is the present surrogacy rate in India when compared to other countries?
See, surrogacy is a 25,000 crore industry, and Gujarat is the biggest hub. India was a hub where there was a clampdown. It shifted to Nepal banned it, it shifted to Thailand. Now it is in Laos, somewhere in Vietnam. Surrogacy rate is still very high. There are no official statistics available because nobody wants to talk about it, because surrogacy is not allowed. It is not allowed administratively, but clinics are very scared to touch surrogacy unless it is a exclusively Indian couple. So figures and statistics is very difficult to get hold of. Even the last bill is not available. So unless the ICMR comes up with some figures, even in the report table before the Rajya Sabha, there are no figures. But I have a feeling that it is a practice which will go into the grey market. If you ban, you will not be able to stop it. There are popular people in the entertainment industry. Karan Johar is one, Sunny Leon is one, Tushar Kapoor is another, Amir Khan was one, Shah Rukh Khan was one. I mean, all of them did it. Who stopped? Nobody. So, as long as it is not noticed, it goes on. But figures, I'm sorry, I'm not able to comment on this. I don't know. Next, please.
Thank you, sir. Anyone else, please may ask questions in the chat box. I'll read it out.
Seep Gupta. Whenever, what if someone is married to an NRI but the guy doesn't have Indian citizenship? Can a girl divorce him under the HMA given that the girl is Indian? Now, good question, but let us first understand who is the NRI. Now, if the NRI is not a Hindu, the marriage could not have been taken, place under the Hindu marriage. Now, if you are a NRI, you could be an NRI of Indian origin with a foreign nationality, or you could be an NRI or a non-resident Indian of foreign nationality and foreign religion. So if you are a Christian and you married a Hindu under the Special Marriage Act, obviously you can take a divorce, and citizenship has nothing to do with divorce. Now, if you are two Hindus and the husband is an NRI, you can only divorce under the Hindu Marriage Act. But if you are a person of foreign nationality, you can take a divorce under the Special Marriage Act. So the girl has no inhibition, there is no restraint on the girl to take a divorce in India. She can take a divorce under the Hindu Marriage Act if they are Hindus by religion. She can take a divorce under the Special Marriage Act if they were married in India and the person is not a Hindu. I think that answers the question.
There's also another question by Seep Gupta.
And my father, another question is, what if two people of different faiths are married under the Special Marriage Act? Will their personal law still applicable to them in wills, inheritance and divorces? See, when you marry under the Special Marriage Act and you are Hindu by religion, you are only opting out on the law of marriage. You are not opting out on the law of succession. You are not opting out on the law of adoption. You are not opting out on the law of other laws of Hindu perspective. You are only opting out. See, you are both Hindus by religion, but you don't want all that big jing bang show of the Hindu marriage. So you just want to go to the registrar and you want to do the civil ceremony. Now that is an option you exercise to marry. You don't opt out to remain out of Hindu law for all other purposes. So it is a opting out only for marriage. All other laws will still apply. Next question.
So next question comes.
If the Present Surrogacy Act is the Present Surrogacy Act fit enough to prevent the offences in this exclusive million fund industry? Whether the Surrogacy Act has an impact on the surrogacy rate? See, you have let it grow from 2005 to 2015. For 10 years it went on unchecked. Now, what happened in 10 years can't be overdone overnight. More so when you are making a law which is yet to stand the test of constitutional validity in the court. What is wrong in people doing surrogacy if people are allowed to do adoptions is a big question. which will have to be settled. So I don't think this surrogacy act is going to be enough to check this surrogacy. It will go on quietly. That's it. The problem will come only when you need a passport or when you need an exit for a child to go out of the country. Because if you say the child is born out of surrogacy, then the question is, how did you do it? The FRRO, the foreign registration office will not give you an NLC to leave the country, and the embassy in the country will not give you a visa. So the problems will come. But domestically within the country, I think the process will go on. And what are the people, what are the surrogates who are in it? What are the doctors who are doing this, who have built hospitals? It's a big question. Livelihood of a lot of people. You can't just, for simple reasons of morality or ethics, one day finally you decide you can stop it altogether. Now this is a question which will evolve with cases over time and maybe then be settled down. So surrogacy rate will not be impacted, and I don't think law can take care of it as it is from what has been laid out. And the next question, what do you think would be a good way to bridge the gap between cultural morality issues and the right of the livelihood of the commercial surrogates in India? You see, the question is very simple. When you become a surrogate, you sign an agreement. And your husband also signs an agreement because technically, under Hindu law, this is adultery. So if you are willingly consenting or agreeing to be a surrogate, deholds your ethical or moral issues. It is an option of choice. There are human rights issues also, of activists also. I remember when we launched our surrogacy book, there were 100 women outside with blindfolds or black blindfolds on their faces. We were not heard. We couldn't hear them. We couldn't take on anything. But there are women who are surrogates who think that the money which surrogacy provides to them is going to help them for the other children. So they see surrogacy as no wrong. But there is also people who view it as commercialized prostitution. So it's a question of your perception. If you are forced to do it, it is wrong. If you wish to do it voluntarily or willingly, you are balancing your ethical issues and your cultural issues and your morality issues. For somebody who is only opining on it as an activist, he is entitled to his view and seek whatever remedy he has.
Good morning, sir. Good afternoon. This was my question. So, the morality that I was talking about was not in context of, between the family, but morality as in what legislators justify with when bringing such an act or such a legislation to curb this commercial surrogacy. What do you think could be a way to curb?
See, it's a question. I gave a TED talk on surrogacy in St. Xavier, Dubai. I think surrogacy has become a commercial venture. See, India is a third world country. We are not a European country, fluent and rich.
Yes, a lot of people.
Prosperous. So it's a question of economics. I'll give you an example. I was asked by a British court to go to a remote area in Punjab where there was a surrogate from Bihar who had given birth to the child of a North Indian couple. And under the Surrogacy Act in England, the mother giving birth is to consent to the parents taking the child in surrogacy before the child is handed over.
Saadi Vajpayee.
So I went to that area. It was a railway colony, a very dense area. So I asked this Bihari couple, what are you doing here? So the man said my father was a railway employee, so he settled there. There was a whole colony of them. And they had a small house of 2 rooms and they had 4 children. And everybody knew that this had happened. So They said we are willingly giving the child because it helps us to buy benefits for the other children. But they also said that if they don't want the child, they should give it to us. If we are for of it, then here we will bring our prescription also. So, for people who are poor, for people who need money, it's not a question of morality or it's not a question of ethical question. It's a question of livelihood. The man doesn't have enough, the man is ill, or there is a so therefore this
There is a humble request that all of you ask your questions in the chat box.
pardon? Yes, is there any other question? My question is now, how does the Indian system deal with the issue of citizenship and implementing any order at this time of outbreak? This is the question on citizenship. Now, I would like to know what exactly do you mean by issues of citizenship? See, there is the Talbighi, the latest thing is the Talbighis, 3,500 Talbighis who are being deported. So the Supreme Court has said that these people cannot be deported without an inquiry. Now, under the Citizenship Act Section 9, unless there is a determination of citizenship or there is a quasi-judicial process, the issue cannot be resolved. Now, in this COVID times, how will this quasi-judicial process take place? Is something which we will need to see. Now, there are supposed to be tribunals in place. Now, if there is an emergent hearing required, then I'm sure by video conferencing these hearings can take place. And it may be necessary, if it is absolutely necessary. If it is absolutely necessary, then a hearing can take place. A hearing can take place. A hearing can take place by video conferencing and an interim order can be obtained to stop the deportation as the Supreme Court did recently, and the matter can be determined. There is no real gravity that the process of law will stop. We are coming slowly. The courts are getting into operation, and there will be a way out to resolve the issue of citizenship also. But since the definition itself is under hold, Citizenship Amendment Act is under challenge, there are 150 petitions. I don't think any drastic steps of deporting people will be taken until this issue is resolved. Obviously, you are not able to bring Himalaya back, so what is the hurry? Anyway, that is the point.
So we'll take another 3 questions.
Yes,
Fill out the form.
There is,
Yes, sir.
ma'am, there is no limit on questions. We can go on. No issue. Don't worry. I don't want
Okay,
any question
sir.
unanswered. Please don't stop
Okay.
anybody.
Yes.
Then, now what is the present legal status of surrogacy in South Asian countries? That somebody put that? Surrogacy in South Asian countries. Now, most countries hire and banned it. It is going on in Vietnam. I don't know about Hong Kong. See, smaller jurisdictions will decide on their own way. And it may go on, but there are no big hubs as of now in South Asia. Now there is the question that NRI is the PR of Canada. Yes, he's a Hindu. Okay. So PR makes no difference. If he's a Hindu, he has an Indian passport, he has a Canadian passport, that makes no difference. So as long as you are a Hindu, your passport doesn't matter. Hindu law will apply to you. Now, isn't it better to allow surrogacy instead of letting it pass in the grey market? Would lead to exploitation of surrogate mothers. Yes, I agree with you. See, if you push surrogacy out and hide it under the carpet, it will go out. It will start illegally. So, as I suggested, and as I think, my personal view is, you should allow surrogacy. Make a regulatory law. Make make a restrictive law, make an authority to decide who is eligible to come. Follow the same procedure as we do in intercountry options. Have an assessment, have a home study report, evaluate the people, see their backgrounds, let them get analyzed, let there be the NOC, let there be a provision of court order, maybe, if you want to be very careful, and regulate. Stamping it out, maybe you will come up with this after 15 years, but I think regulating it and restricting it rather than stamping it out would be a better idea. Could you please explain the current succession disputes of the parties who made the will was an Indian and has left properties in different nations? See, as I told you, if you are a person, you may be a Canadian, American, British, German, you have properties in India, say movables, say bank accounts, say fixed deposits, say shares, say land. All this is in India. Your succession to these properties will be governed by the Indian law of succession. If you have left a will, they will be divided according to the will. If you have not left a will, they will go by law of succession, that is the Hindu Succession Act. If you, for example, in your bank account, you have nominated somebody. In your shares, you have had somebody succeeding to them. They will go accordingly. As far as land or immovable property is concerned, it will go by your will. If not the will, then under the Succession Act. Now, insofar your properties in foreign jurisdictions are concerned, movable and immovable properties in foreign jurisdictions will be decided by the law of the country where your properties are. Because law of domicile means whichever country in which your properties are domiciled, that law will be applied. How the principle of comity of courts and foreign shopping will help the case of inter-country adoptions. See, foreign shopping in inter-country adoptions doesn't seem to read somehow. See, foreign shopping is when you choose to have different beliefs from different forums. This is more so in the case of custody. You try your luck for custody in a foreign court, you don't succeed, you come to India and you start following. This is foreign shopping. Now in inter-country adoptions, foreign shopping will not work because India is a signatory to the Convention on Adoption. So you have to go under the CARA. You cannot get a foreign court order and have it implemented in India. You have to go through the process of the domestic law, that is the adoption regulations which are governed under the adoption. So foreign shopping has no place in inter-country adoptions. Please explain the word of distinction of intra-country adoption. I have not understood. See, intra-country adoption is when within India you want to do adoption. There are a lot of children in welfare homes or with adoption homes who are offered for adoption. They are first offered domestically within India. If the child can find an adoptive home in India, it is called an intra-country adoption within the country. Inter-country is when you want to take a child from India to a foreign country. Intra-country adoption also takes place when the parents who are giving an adoption and the parents
I request you all to please stay online. There appears to be a technical glitch. We will rectify it as soon as possible. It is at sir's end. In the meanwhile, I request you all to kindly keep your mics muted.
ഏതോ കനകപ്പാതി ആരൊക്കെ വീഡിയോ നോക്കി
We are trying to contact sir. We are waiting for his response. Please stay online. Thank you.
Sorry, I got disconnected. Can you hear me? Hello?
Yes, sir. Yes, sir. We can hear you.
Yeah,
Yes, sir.
I'm sorry I got disconnected. Yeah. Yeah.
Yes, sir. That's not a problem. We are waiting for you.
What about surrogacy and adoption among couples once it's legalized? So I've already said that we will have to reconcile our laws. We have to see that adoption and surrogacy go hand in hand. We have evolved a very progressive law on adoptions because of the efforts of Mrs. Menka Gandhi, who was Minister of Women and Child Development, spearheaded the amendments. But the surrogacy front is still very poor because India has taken a stand that they will not allow surrogacy for foreigners, and I think same-sex couples are still very far away. So this is not going to happen for the next 25 years. Next, can LGBT couple adopt the child if they reside other country but from India? Yes, you see, if you fulfill the requirements of CARA, because under the JJ Act, adoptions are permissible irrespective of marital status. And if you qualify the conditions of CARA, if your own study report is in your favor, if the conditions are met with, it's permissible. It's a question of satisfying the requirements of the law and the conditions imposed by the Act and the regulations. If you qualify, you will succeed. Okay, next question. Can you hear me? Hello?
Yes, sir. You're audible. Yes, sir.
Can a surrogate mother claim the ownership of the baby and decide not to return the baby to the biological mother? Now, let me answer this question in a way. Before you enter into surrogacy, you sign a contract. The contract very clearly says that you are taking money and you will give up the child. You will not claim rights to the child, you will not decide that you have changed your mind, etc., etc. So it's a question of a contract. And once the baby is born, you can't say, I have not developed motherhood issues, so therefore please let me keep the baby. You can't have your cake and eat it too, so that may not be permissible. But there are issues that people may want to abandon the baby. Unfortunately, the child suffers from some disability or there is some problem. that again is a question of issue and how to handle it, and that the law is not taken care of. We need to evolve a system whereby we can ensure these rights to be implemented. As of now, the question is under the Indian Contract Act. How can you enforce the contract for service? Now, if you take a dispute to the civil court, section 9 CPC, courts to enforce all civil disputes. Now, all civil disputes means disputes which are enforceable in the Contract Act. So this is a grey area, not yet developed, can't say. Difficult. And adoption without a deed is Hindus allowed? Yes. See, under Hindus in the Hindu Adoption and Maintenance Act, the adoption, as far as Hindus is concerned, is only by a ceremony. So you do a ceremony of Datta Homan. You give and the someone takes. So if giving and taking is done, Hindu Adoption and Maintenance Act says nothing more is required. So you can obtain a certificate from a temple or a religious place. You can get it registered. Those are all optional. But without a deed, adoption is allowed. You can record it, it helps, but it is not mandatory nor is it compulsory. Next, if a foreigner is married in India under the Hindu Marriage Act, after marriage, he had to return to foreign again, he can sue for divorce there. Of course. See, I married in India, I go back, things don't work out, I can divorce. You can divorce under the Hindu Marriage Act by filing a divorce petition in India. You cannot resolve the Hindu marriage in the foreign country under the foreign law. But you can file a petition for divorce in India. Wherever the marriage was solemnized or wherever the wife lives, you can even appoint a power of attorney holder to pursue your petition. You can even give evidence by video conference. And what is the condition of adoption/surrogacy for India in the LGBT community? Now, I've already told you the law applicable for adoption is the Juvenile Justice Care and Protection of Children Act, under which persons irrespective of marital status are allowed adoptions. So is the position under the adoption regulations. But as far as surrogacy is concerned, there is no surrogacy as of now is confined only to infertile Indian couples. So it is only men and women with a marriage of 5 years, now reduced to 2 years, that the surrogacy is permissible. So LGBTQ do not satisfy the test for surrogacy. Then my question is, you talked about the decision granting divorce by mutual consent to parties in circumstances. Consent was given by 142. Yes, you see, if you are divorcing by mutual consent and the Supreme Court is doing that, exercising the powers under 142, it is a decree by consent. So if you suffer a decree or a judgment by consent, you cannot go to another jurisdiction and say, no, I have changed my mind, I don't agree. Law stops you from changing your stand, and forum shopping prohibits you from raising the same question again and saying, no, I want this whole thing to you. That's not allowed. Next, shall you explain about reciprocating directly and implementation of foreign judgments in India? You see, under section 44A of the CPC, if we are reciprocating directly, for example, UK is one. Decrees interested between two courts will be implemented as acceptable judgments. But the questions are, the judgment has to satisfy also section 13 and 14 of the CPC, as I explained to you earlier, about the implementation of judgment and the condition the judgment must fulfill according to Indian law. So reciprocating directly is the stepping stone for implementing a judgment in which there is a treaty between India and another reciprocating country, but the test to satisfy would still be under the 13 and 14. Then can an Indian foreigner marry a foreigner in India? Can an Indian marry a foreigner in India? Yes, of course. An Indian can marry a foreigner. The foreigner may be an Indian, a Hindu, or the foreigner may be a white person or a person of Christian religion. If if you are marrying a person of another religion, you marry under the Special Marriage Act. If you are marrying a Hindu who is a foreigner, you can marry under the Hindu Marriage Act. What is the current law to deal with fugitives, especially fleeing a country after doing economic offenses, civil offences? You see, the Extradition Act of 1962 is the act by which you have to, between two treaty countries, a person can be extradited. UK is an extradition country. In the child abduction matter, which are an amicus, we tried to extradite the lady who had moved the child because the Extradition Act was there. So the procedure is you apply, as was done in Vijay Mallya's case or Chokshi's case, you apply to the country does a process of its own. It is obviously open to judicial review. And under the Extradition Act, you can seek the person's return back to India for economic offences to be brought back to trial in India. It's common, it happens, the process is cumbersome, it takes a lot of time. Then recently a bill was tabled by Parliament, Unity and the Surrogacy Law. I think you've done this already, yes. Sir, when a child is a refugee with different religions other than Hindu, but he loses his biological parents. You see, if a child loses his biological parents and is a refugee, see, the child will be immediately taken over by the Child Welfare Committee. See, you often have abandoned children. And just let us compare this child who is also abandoned or is a refugee without biological parents. The Child Welfare Committee, under the Juvenile Justice Act, in every jurisdiction, has powers to take over such children, issue a public notice in an advertisement in a paper, saying so-and-so child has been found in so-and-so place. If nobody claims him, the child will be put up for adoption. So the child is lodged in a home. The child will thereafter be offered for adoption after exhausting the process. Until such time, the child will be put in a home and will be looked after. Next question. Europeans and Americans are said to be playing a major role in surrogacy industry in India. In another angle, female feticide is very high in India. What can be done to control the same? I wish I could do something about it. Anyway, to answer the question, female feticide is high in India.
See, now the COVID issue, we really can't say. Probably in the form of a web series.
No, we can keep with it. You choose topics.
Yes, sir.
We can take up topics individually also. I've opened up everything to you. You
Yes,
can
sir.
pick up topic of your choice and students' choice. I see a lot of interest. You see, I went to Pune. They wanted me to talk on prenuptial agreements and relationships in the nature of marriage. So every jurisdiction you go, everybody has a different issue. So
Yes, sir.
you can circulate in your college, whatever in your campus. I see students are pretty bright. They have a lot of questions. You are 100% literacy state. I expect people to be with a lot of brains and not brawn, as is in the north. So
We hope to come up to your expectations, sir. So.
choose the topic and it's on.
Yes, sir.
And when I come, I will
Yes, sir.
bring copies of my book. The book answers it all. I have been working on it non-stop for the past 6 months. So that is why everything is in there. I don't have to read anything. So you asked me for a pen drive. The pen drive is inside.
Yes, sir. So, and to summarize all these technicalities with respect to conflict of laws and to us is that's what I was saying is highly unreasonable. So thank you for opening the floor for collaboration.
You have to see the court. See, I travel to courts all over India. There's not a country, there is not a forum, there is not a platform internationally I have not been to or spoken. South Africa, England, America, Canada, everywhere. So the vistas are open. And I'm a fellow of the International Academy of Family Law Lawyers. It's a who's who of family law,
Yes,
700
sir.
people. So there the exchanges are very vast. We are still a very poor family law jurisdiction. We have not developed the law. We did a webinar with an English judge and a judge of the Delhi High Court. And we still have to go a long way. See Australia. Australia has a Chief Justice of the Family Court of Australia. So family...
Sir, on that note, if I may ask a small
Yes,
question
please.
to you, sir.
Yes, sir. So, sir, in our introductory address by Honorable Justice Mohammed Mustaque had mentioned about transformative change in private international law. In the Indian context, especially since you were saying that it is to do with private international law with respect to India, is mainly to do with family law issues. Without having a uniform civil code, is it ever possible to have a unified system of private international law with respect to India?
You see, we can do it provided we sign conventions. See, we have done it in adoptions.
Yes, sir.
We have got a wonderful system in place with the adoption convention. We have signed the UNCRC, United Nations Convention on the Rights of the Child. Now, these have to be put in enabling legislations. Now, the Supreme Court said, following these conventions in Daniel Latifi, that everybody is free to adopt. Even Muslims are free to adopt. Now, adopting outside blood is not permitted in Muslim law. But the Supreme Court says the JJ Act applies to Muslim children also. So the uniform civil code we will never have a uniform civil code. But we can reconcile to foreign laws by signing international conventions and making enabling provisions to give them teeth. That's the way to do it. For example, in inter-country child removal. If we don't want to sign the convention, we should make a law. Irrespective of religion, whether the children are Muslim, Hindu, Christian, Jews or Parsis, let there be a uniform child custody law for all. So you move away from Hindu Minority and Guardianship Act. You move away from Muslim children law. So once you are in the ambit of a uniform law, see 125 CRPC. Shah Bano said, Muslim, Hindu, Christian, 125 applies to everybody.
Yes.
The answer is in legislations. The answer is not in UCC.
Okay.
See, we are a country with so many religions. UCC is an impossibility, particularly when statutory laws, the Parsis law, the Christian law, the Hindu law, the Muslim law, they are so much in place and they are all statutory laws made by Parliament. So making a UCC, not in this century.
Yes, sir.
Very, but this is opening up private international. You see, I foresee in the next 50 years an international family law. With people moving across so much. And see India, we are 1.3 billion, but 30 million live abroad. 30 million is not even the population of most European countries. So these people will probably ask it. You see, you want a divorce on irretrievable breakdown. It's not available in India. So you divorce in Canada. You don't care. So we have to change. We have to bring in changes to adapt to law. We can make changes in our law. Or we sign conventions. Convention is, I think, the answer. And I think practice direction by Supreme Court, mirror orders. We need very bright judges like Justice Mishra. See, there is an apostolic convention. Previously, every document brought from a foreign country had to have notarization, counter-attestation. But Justice Mishra says under the apostolic convention, all this is not necessary. I cite that judgment everywhere. And if there is a document or a wakalatnama, say, or an affidavit which is not attested by the High Commissioner of the country, I produce it because the apostolic convention says it's not necessary. But how many people know it? Very few. But then the judgment is held.
Yes, sir. So, sir, shall we come to the end of the session with your permission? Thank you once again.
Yeah.
Thank you so much. We look forward to associating with you in some way or the other in the future.
And I will await the video as soon as it's ready.
Yes, sir. We'll forward the link. Yes, sir.
Thank you very much. So nice of you. Bye bye.
Yes.
All the best.
Thank you. Bye. Thank you. I thank all the participants for being very cooperative and switching off the mic and being very participative as well by asking wonderful questions. Thank you once again for being part of this session. We will be interacting with Sir in the future in all areas of private international law. We look forward to your participation there also. So thank you.